Morning. Go ahead and be seated. Hey, our first case up this morning. Okay, if you'd like to come up.
Thank you.
And would you like to reserve any time?
Thank you. I represent Boulder Cab, also DBA Deluxe. Thank you for taking this writ. It is a very important issue of law. I think it needs clarification. That's why we asked for this. And our consequent client. I'd like to get to the factors under Breitbart of retrospective versus prospective, retroactive. We maintain that the Thomas decision was the new law. Until Thomas, the statute 608-250 sub 2 was still the law. It had been on the books for 5 decades.
Counsel, don't we make, just at the onset, don't we make a distinction as to a constitutional change versus statute? It isn't a constitutional change. In essence, trump statutory change or difference?
Trump, the word, yes. You had an amendment, plain language. Judges below, other judges sitting here today disagreed, saying, I can read these in harmony. Now, if that constitutional amendment, the minimum wage amendment, if that was so clear, how come everybody didn't agree? And how come Boulder was supposed to know this happened and change its business practice,
Whether they
which has
agree
been
or-
there for decades? I'm sorry.
And it's not been invalidated, so why would someone think otherwise?
What you're talking about is in 06 when the amendment took effect, it clearly changed the minimum wage. Did it clearly declare declare 608-250 sub 2 unconstitutional? I say it did not. The Department of Labor didn't think so.
Isn't there a section to that gives exemption? Doesn't it pertain to a specific?
Yes. It's not that statute. It's a lie. I maintain that until you declare subsection 250 sub 2 commission.
But that, as I indicated, that's kind of belies and part of the problem.
100%, and if it were more clear, we wouldn't be here. Had the legislature, after they met, after the amendment, said this is now repealed, it's unconstitutional, and that's why we satisfy the factors in Breithaupt.
Counsel, I was interested in getting your take on is opposite your position. How do you address Judge Dew's position here?
I guess I would say the same thing, the same factor because I wasn't there, was going on in the first decision in Thomas. There are consequences to judicial decisions. And if you rule a general rule that's in case law is prospective, judicial decisions. The Bright-Hop factors had that judge had information like is before you.
Great Thurman, how would you articulate in the opinion the factors that are before this court that were not in front of Judge Dew that arrive at a different result?
Well, the factors as well as the evidence that's in the appendix in the record below, that's
well,
correct.
I'm giving you an opportunity to highlight the points. I mean, you appropriately argue that we're an exception. So let's focus on what are the issues, what are the factors that are in this record that make it so much different than the analysis that the federal court gave to it.
Our Supreme Court, this body before said one of the factors is substantial and reasonable reliance on previous law, which we have done. The statute was not clearly repealed, was not expressly repealed. It was impliedly repealed through some effort by we could not. 05, I didn't see it. We never saw it. But they requested it. We have been paying minimum wage. It's not guaranteeing it. Most cab drivers make more than minimum wage.
That brings me participate in the deliberations afterwards. So with that being said, you just brought up a point. All this, assuming that that were to happen, when you've got commission-based employees who may or may not be above or below minimum wage based on commissions.
How do you go back and do it?
How do you figure it out?
It's very difficult. And we've offered all of our records, including the documented records of the hours worked, which I've seen the brief saying was violating law. That's not true. Trip sheets are maintained, and you have to go back and look at the trip sheet. We've offered those to council. They don't want to look at it. They want it on computers so they can run a quick analysis. What you do is you've got the total revenue from the shift, how much he has made. There's a part where you reduce the federal tips, and then you can put in the hours, and you can figure that out. You can. You don't have to count tips. But
Okay.
it's painstaking to do. And we've offered that to this side, and they just don't want to do it.
Could I ask you to return to another, maybe I didn't articulate the question I wanted to.
Certainly.
The third factor under Bright-Hop applying
Inequities.
Chevron is the inequities. What in this record establishes inequities in this result that were not present in the Thurman federal court case?
Well, I'm not positive what was up there, but I would hazard an educated guess. What wasn't there was the evidence we put in as to our business and how we run it, how we comply with the law, and how much money we generate. We are the smallest cab company, restricted, at least at that time, to the southeast part of the valley. Couldn't pick up on the resort corridor. We generated the least amount of revenue per shift and per medallion. He was serving that area as he was ordered to do by the state. This is financial consequences to him. He doesn't have that kind of margin. And should you rule retroactivity should apply, the consequences to Boulder Cab, while bigger cab companies might have a bigger dollar figure, the consequences to it is much more severe and dire. I furthermore state, just having to pay back pay Okay. Penalties? This is a high turnover job. Guys come in for a week, they don't like it, they leave. We're going to pay penalties on this? Attorney fees, punitives? This is inequitable, especially when you consider the largest cab company, collection of cab companies, the freest companies. They are not subject to this. They don't have to pay punitives or attorney fees. They're exempt under the MWA, the amendment, because they have collective bargaining. The industry, and I've been doing this for a while, the way cab drivers are compensated at Boulder, at Yellow, at Frias, it's all pretty much the same. It's commission. Unions at the bigger companies negotiate health care, different things over the years, and we have to offer the same thing to compete. But now Frias, who can afford much more than we can, is exempt. That's substantial inequities, I maintain.
Well, one of the issues that Judge Dew mentioned in the federal court analysis on this very issue was the question about reliance on the Lucas decision. You're not arguing that here. Are you saying that Boulder relied on Lucas in 2011?
I can say without question my client did not read the Lucas opinion. He probably heard of it. I did not read it until we got sued. I heard of it. I've seen mentions in the brief we should have filed some kind of debt relief action. Well, the judges were all ruling the statute is still there. It's still valid. Cab drivers are exempt. We knew of the Lucas opinion. We knew of it. I didn't read it. My client didn't read it until after we got sued. I'm sorry. But
Mr. Winter, can I ask you one other question on retroactivity? It's a very interesting issue. Here we have a constitutional amendment, and as Justice Douglas points out, it might have a different interplay than on statutes. But we have a couple recent Supreme Court decisions on retroactivity on statutory interpretation, and one a number of years ago called Sandpoint, one very recently called Badger. They were split decisions, but the majority in both concluded there was no retroactivity with these statutory changes. Do these cases have any interplay with this issue, or are they irrelevant in your point of view in making this determination?
you know, it's always difficult to confess that I haven't read those, but I haven't.
Well, they're on real estate personal guarantees and foreclosure issues, so they're not on the subject matter we're talking about here, but the principle announced in those cases. I'm just wondering if you had thought about that.
I haven't thought because I haven't read it.
Okay.
I've read our case, and the law here is Bright Hop, and I say that is good law, and you should follow it.
Very well.
I'm certainly willing to entertain any questions right now, but I'll sit down then, and thank you.
Okay, thank you. Okay, Mr. Greenberg.
May it please the court, I'm Leon Greenberg, and I'm arguing today on behalf of the respondent. To answer some of the questions or address some of the issues raised by the bench on petitioner's argument, Justice Douglas, you are correct in that the exemptions that the industry was relying on, which are contained in 608.250 subpart 2, are specifically worded as an exemption to the minimum wage requirements that are set forth in 608.250 subpart 1. Their exact language is not declaring an exemption in Nevada from all minimum wage requirements that may in fact be imposed upon employers, but only the ones set forth in the preceding subsection. So for anyone to later take the position that a subsequently enacted law, such as the constitutional amendment, is subject to those exemptions, is essentially turning a blind eye to the actual language of the exemptions themselves, which are limited by their text. Now, in respect to the assertions that have been made here that there was a reliance by the petitioner and its industry on prior precedent, there was no prior precedent from this court. The constitutional amendment was enacted in 2006. They didn't have any prior ruling that was stare decisis to rely upon.
But counsel indicated the district courts, in fact, interpreted, that did interpret how the Constitution and the statute interplayed, were finding that the exemptions weren't wiped out by virtue of the amendment to the Constitution. Is that incorrect?
Your Honor, we had a decision from Judge Jones, District Judge Jones in the U.S. District Court in 2009 in the Lucas case. That is not binding precedent. That is the opinion of one jurist in a district court on this issue. If the Lucas plaintiffs had in fact been successful in appealing that decision, and they were not successful in part because Judge Jones denied their request to certify the question to this court. But if they had been successful, we would have had the decision in Thomas, presumably years earlier, and the plaintiffs in Lucas would have benefited from the recognition that this court made in Thomas that Judge Jones' analysis was
What about the
error.
district courts? There were several cases pending in the district courts. Were they inconsistent in the way they were making their determinations on these various cases?
There were a total, Your Honor, of 4 decisions that were rendered in 2012 through 2013. One was in the Gilmore versus Desert Cab case, which this court subsequently reversed as an error based upon its decision in Thomas. There was also a decision by Judge Corey in Murray v. ACAP, which agreed with the analysis of this court in Thomas and the analysis of the Attorney General, Brian Sandoval, in 2005, which put the entire industry on notice as to the analysis that this court ultimately adopted in Thomas. Now, that brings us to this point of foreshadowing. I was explaining that there was no prior precedent that they could rely on. They say, well, it wasn't foreshadowed what this court decided in Thomas because we couldn't know that the court would arrive at that decision. There were differences of opinion. I mean, we had other judges. We had a portion of this court that took a different view of the application of the Constitution. Well, that claim is turning the meaning of the word foreshadow completely on its head. I mean, the Oxford Online Dictionary defines foreshadow as, quote, a warning or indication of a future event. A foreshadow is not a prophecy. It's not a 100% accurate prediction of what is going to happen. It's a warning that there is a significant chance that something may logically come to pass in the future based upon the information that is available to you in the present. If I get up in the morning and I look out the window and I see that there are dark clouds on the horizon, well, I've been told that there may be a storm later in the day, and maybe I want to take my umbrella before I leave my house. If the storm never comes, well, that's a possibility. But if it does come, I have no one to blame for not bringing my umbrella but myself. So to the extent that the industry here is claiming that they were justified in their failure to follow the Attorney General's opinion or the opinion of the Little Mendelsohn firm, which is counsel for Sun Cab, amicus in these proceedings, who also issued a public advisement to all Nevada employers in 2006 that numerous employees, including taxi drivers, would be covered by the constitutional amendment. The Littler firm is the largest employer-side labor law firm in the entire United States. So one would think that their advice had some sound basis. Now, it is true that this court does not always agree with the opinions of the Attorney General. But as I was explaining, to foreshadow is not to predict with certainty. It's a question of being informed as to a reasonable possibility, a reasonable
Now,
likelihood.
just going to that point, understanding how this court struggled with the issue and the division in the court on that very issue, I mean, if we couldn't come to a 7-0 determination on it, how does that affect your foreshadowing argument?
The issue is, as we all understand and learn at a very young age, that ignorance of the law is not an excuse. In Barlow v. United States in 1833, Judge Story stated, and I quote, "It is a common maxim familiar to all minds that ignorance of the law will not excuse any person either civilly or criminally." Now, Judge Story went on to explain that the reason for the rule is to put individuals on a basis that they need to inquire, that they can't simply be blind to the clouds that are gathering on the horizon and the possibility that the storm may be coming later in the day. And to quote Judge Story again, quote, "There is scarcely any law which does not admit of some ingenious doubt, and there would be perpetual temptations to violations of the laws if men were not put upon extreme vigilance to avoid them." This rule of law is inherent in our system of justice. It's existed. We're going back to not just Judge Story, but Blackstone, Magna Carta itself, which we're now celebrating an 800th anniversary of, that individuals are charged with the duty to ascertain the law. Now, if the law is completely unascertainable here, perhaps the petition would warrant a different view and a different means of examination. But clearly the law was not unascertainable. This is not a situation where the industry and the petitioner had absolutely no inkling that this could come to pass. Clearly they knew that it could. They made a conscious decision to not inquire, to not conform their conduct to what was ultimately decided by this court in Thomas, or not to affirmatively ask the courts of the state of Nevada to make a ruling and determine this issue. Now, counsel for Boulder Cab was just noting that the Freest Companies, which is the largest operator in the industry here in Las Vegas, is exempt from the law because they have a collective bargaining agreement. They're not exempt by virtue of having a collective bargaining agreement. They're exempt because they negotiated specifically with their drivers' union and achieved that at the bargaining table, and that is a function also of the supremacy of federal labor law. Now, that happened in 2008. So clearly the industry was on notice and knew that this was an issue. Petitioner Yellow Checker Star similarly attempted to negotiate such a waiver with its union starting in 2008. And this is documented in the record. They were unsuccessful in doing so. And subsequently in 2013, there was a 60-day strike at Yellow Checker Star in connection with their contract negotiations, and they still didn't secure that waiver. So this idea that the law was not reasonably ascertainable to the industry here or to the petitioners has no basis in reality. They made a decision that they would simply force their drivers to sue them if their drivers wish to exercise their rights under the Constitution to these minimum wages.
Mr. Greenberg,
Yes.
could you respond to an issue I have? In this case, the appellants argue that, the petitioners argue that the court should apply the test in Brayhop to avoid the retroactivity consequences of the Thomas decision. Is the Brayhop case even applicable here? In that case, this court was dealing with competing interpretations of an insurance statute. Here, we're dealing with whether or not the provisions of an existing statute were repealed by the constitutional amendment. As well, there's been considerable criticism of the Chevron case under which the Brayhop decision was entered. Would you comment on those issues?
Yes, Your Honor. The criticism of the Chevron decision would actually narrow or make less available the potential for prospective relief, as this court was discussing in the Brayhop decision. Now, Brayhop was not actually dealing with a newly enacted statute and a question of a defense to a newly enacted statute and the overruling of that defense, which is the precise situation we have here. In this case, if one was reading the constitutional amendment in isolation, there is no question that the taxi industry is covered by the amendment. I mean, the language is absolute. It states every employee shall be paid a minimum wage by their employer, except as specified herein. There's no specification taking taxi drivers out of that coverage. What the industry did is they came in and said, well, look, yes, that's the language that's here, but if we look at the prior statutory scheme, if we look at the fact that this language doesn't mention the prior statutory scheme, it creates a question of ambiguity by essentially silence, or a question of that well, should we really be looking at what the voters intended? What was the purpose and intent behind the constitutional amendment when it was enacted? This court ultimately rejected that analytic approach to the scope of the statute and said, no, we must apply it as enacted because that is the nature of our law. Now, they were free to make that argument, and they did make that argument. They raised that defense. They forced their drivers to go ahead and sue them and overcome that defense. Well, they lost their gamble. They lost their bet. They don't now get to come and tell the court, well, give us absolution and we'll go and sin no more, and that'll be enough. I mean, that's not the nature of our system. But to specifically answer your question about Breithaupt, further, Your Honor, in Breithaupt, there was prior judicial precedent that this court was considering whether to retroactively overrule. It declined to do so. There was also the statute that changed the law because the legislator decided they didn't like that decision by this court. Now, here, we don't even have a prior precedent from this court. There was no prior decision from this court that the industry could rely on because the court had never ruled upon their defense to the constitutional amendment.
So assuming the court said, well, yes, whether under Breithaupt or under general rules that the Thomas case applies retroactively. In this instance, counsel has argued that it would be inequitable to apply it retroactively, a third element in Breithaupt. What is it about this record that makes the enforcement of this decision inequitable to the petitioners? Is there something unique in this record that would cause this court to say we're going to disregard these general principles?
There is nothing in this record supporting these claims of inequity. All we have are assertions from the petitioners that this would harm their business, it would harm their financial interests. Counsel for the petitioners just stated that they are a small business. This would be very difficult for them. We have nothing in the record asserting this. I mean, for all we know, if they had followed the law in 2006, or if Thomas had been issued in 2006, they would have operated in the exact same fashion and still made a handsome profit in their business. Perhaps a little bit less of a profit because they would have had to pay slightly larger wages.
Is there anything in this record that suggests that this company operated different after the Lucas decision in 2011, which seemed to contradict the Thomas holding?
This company essentially adopted the same ostrich head in the sand position to the law as the entire industry, except for the Freest company, which actually negotiated a waiver, and Yellow Checker Star, which attempted to negotiate a waiver. They essentially ignored the law and waited to be sued. And now they're here complaining that they're going to have to pay the price of the decision they made. But they had options. They could have gone to the legislature, asked for financial relief for their industry to pay these wages. They could still do that, actually. They could have gone to the people of the state of Nevada and attempted to have the Constitution further amended to address these perceived inequities. There is nothing in the record supporting their claims that this decision will be inequitable or will render an improper hardship upon them or their industry. My time is up.
It is, and let me ask my colleagues, do you have any other questions you'd like to ask? None? Thank you, Mr. Greenberg.
Thank you.
If it pleases the court, briefly, while ignorance of the law is no excuse, we are entitled to know what the law is, aren't we? And if the law is going to change, shouldn't that be done clearly and announced
But
clearly?
you have a constitutional amendment that textually is adverse to your position. And Thomas read that constitutional amendment adversely to you. But I don't see this as a Breithaupt position, because when we construe a constitutional provision, we are saying what that constitutional provision says at the time it was enacted and thenceforward. So I'm having trouble putting the Breithaupt shoe on this foot, if you will.
Well, I don't know if I can help with that sizing,
You
but
might
I'll do
be
my
able
best. As I recall reading the law, when you interpret an implied repeal, this is kind of general principles, you do the same thing with statutes as constitutional amendments. It's the same standard, the repugnancy standard. And I know 4 of you used that language, said they are irreparably repugnant, and I get that. If the law or the standard had been in conflict, you would use that language. I suggest to you that we relied on the old law. And Breithaupt, even though it was talking about statutes, isn't that the same standard? But isn't an implied repeal for statutes the same as amendments? I think that's the law. I didn't cite it, but that's the law, I believe. You use the same standard, repugnancy. So I think we're entitled to know what the law is, and if it changed, and I think it clearly did under Thomas. I respect what you're saying. I understand it. And you say if something in 06 repealed it, it happened then. We didn't see it. Most judges didn't see it until you ruled. And that's why we find the inequities here so compelling.
So you take that your position is Breithaupt applies even though it's an imperfect fit.
I don't think it's imperfect. I think it, the second standard, for example, which I don't think applies here, that would have been the instance. There was a case, I think it was Emerson out of California, where default judgments, some guy challenged him and said due process violation. Well, the Constitution's been around for a couple centuries. And they looked at that and said, ooh, he's right. He's right. There's a due process violation. Well, we're not going to go redo all of these things here. No. We're going to make this prospective. Just like Miranda, when they said you got to tell the defendant, he's entitled to certain rights. They didn't retry all these cases. There are factors involved in equities. Now, that one doesn't apply here, that middle one under Breithaupt, but I say Breithaupt applies, and I hope you do. And now I think I should sit down. Thank you.
All right, thank you. Before you sit down, colleagues, anything? All right, thank you both for your presentations. The briefing was very good in this case. We appreciate your time. And let's go ahead and reconstitute for the next case. Partially reconstitute.
50%.
50%. Okay, next case on calendar is docket number 68975, Yellow Cab versus Thomas. Essentially, we have the same issues, and Mr. Trimmer, are you ready to proceed? All right, come on up, sir.
Good morning, Mr. Chief Justice, Associate Justices, and thank you for the opportunity to argue in support of our position. Like Boulder City, in the case that you just heard, Yellow Cab is here today seeking writ relief from the district court's decision that Thomas versus Yellow Cab should be applied retroactively. And the outcome of this case is controlled by the court's application of the 3-factor test in Breithaupt versus USAA Property Casualty and Insurance Company. And rather than going through my prepared remarks, I think it might be best to start with some of the issues that were identified in the last argument. There was concern that Breithaupt doesn't fit this situation because Breithaupt didn't involve a constitutional claim, whereas Thomas did. And although that's a difference, I think it's a distinction without a difference. Breithaupt relied on the Chevron oil versus Husan factors articulated by the Supreme Court. That case involved a constitutional claim, involved the retroactive application or the retroactive application of a defense to an excise tax that was ruled unconstitutional under the Takings Clause. In Husan or Chevron oil, the Supreme Court used the 3 factors that this court adopted in Breithaupt to find that retroactivity wasn't appropriate under the circumstances in Husan. If you read Breithaupt, and with respect to the way Judge Dew read Breithaupt and Thurman, Breithaupt is not limited to situations where there are differing interpretations of the statute. Its three-part standard is very clear. It applies to this case, and it's been applied without the limitations identified in Thurman or the limitations suggested in questioning during oral argument. In this court's most recent decisions, Garamong and Halpern, both of those cases said that Breithaupt continues to be good law. Under stare decisis, this court should apply it.
Well, but counsel, the underpinnings of the Breithaupt decision was Chevron. That was in 1971. The United States Supreme Court itself, in Harper, in Griffith, has repeatedly criticized, if not impliedly, overruled Chevron. What do you do with those decisions?
First, I think it's important to consider the chronology of when Breithaupt was adopted. The decisions you just mentioned, those Supreme Court decisions that cut against the Chevron oil factors, all of those were issued prior to this court's adoption of the Breithaupt, of the Chevron oil test in Breithaupt. And in fact, this court flagged those and referenced those decisions in the footnote 2 of the Breithaupt decision. It recognized that there was some dispute about the continuing validity of the three-prong test in Chevron oil. Nonetheless, this court adopted it, and it has adopted it without further, or applied it without further comment in two recent decisions, 2013 and 2014. I think there shouldn't be any dispute that Breithaupt applies to this court. The constitutional issue doesn't make a difference. The prior decisions, or the decisions subsequent to Chevron oil, although they're certainly there, they were considered at the time that this court adopted that test.
But there was no judicial interpretation in this case that was arguably mandatory precedent. And in Breithaupt, there was, before the legislature acted to do whatever it did to the insurance statute, correct?
That's correct, but I don't read Breithaupt that narrowly.
Okay.
I think that Breithaupt stands for the proposition that if there is controlling authority, if there's some reason why the situation isn't clearly foreshadowed by either the law or due to judicial decisions or some other issue, then the litigant in our position is entitled to invoke those factors.
So would that be true every time there's a new interpretation that was unforeseen perhaps, but nonetheless foreshadowed using your opponent's definition of foreshadowed? Every time we make a ruling that interprets something in a way that surprises someone, then we have a Breithaupt problem?
I don't think that our position would require you to adopt that interpretation or to apply the Breithaupt factors in that way.
Why not?
Well,
You're arguing that Breithaupt is a natural follow-through as a result of a unanticipated constitutional interpretation. We have lots of constitutional provisions in this state that have never been considered by this court, going back to the 1800s. So we decide one that is now presented, and all of a sudden, Breithaupt is invoked?
Well, let me separate that question into two parts. First, I don't think that applying Breithaupt in this situation runs the risk that normal decisions about the meanings of statutes are going to cause this court to consider Breithaupt in every case.
What would separate it? What would separate it?
What is the articulable limit that would distinguish this case from the floodgates argument I'm making?
Certainly. First, the record establishes that the Thomas decision was not clearly foreshadowed by the facts as we confronted them in 2009, as we confronted them in 2006, and then again as we confronted them in 2013. And let me start with some of those factors. First, Thomas did not find that the constitutional amendment expressly repealed 608-250. It found an implied repeal. And second, it found an implied repeal based on the application of the canon of construction, the expressius unius clause. As I'm sure all of you know, based on such things as Carl Llewellyn's 1949 article about judicial canons, for every canon that applies, there's a counter canon that applies. And this court found in Thomas that the 608-250 and its exemptions would be repealed, but it was an implied repeal in a split decision. And that alone suggests that this was not clearly foreshadowed. Second of all, and I think this is important, it wasn't brought up in the argument earlier, the labor commissioner who's responsible for interpreting and applying this law from 2006 onward took and this is established by Mr. Sackelheid's declaration, which is in the record, the labor commissioner did not find that these exemptions were repealed. And the cab industry reasonably relied on that. Under this court's decisions in cases such as City of Reno versus Reno Police Protective Association, the fact that the administrative officer responsible for enforcing the law is not taking the position that the exemptions have been repealed is extraordinarily strong evidence that we were entitled to rely on the continued applicability of these exemptions.
Stronger than the opinion of the Attorney General of the state,
Yes.
which was a competing position taken at about the same time?
Yes, I
mean-
think that it is. The Attorney General was requested to provide an advisory opinion under the NRS 607 and under the way that the governor has chosen to enforce the minimum wage amendment. He has delegated his authority to the labor commissioner. The labor commissioner under law has the ability to interpret the minimum wage amendment, or at least that's the position that the government has taken. And under this court's decisions, the labor commissioner's interpretation of the law is the most influential interpretation other than this own court's decision in Thomas. Now,
You keep applying and going back to Thomas and the activity in Thomas when it was decided, but the constitutional amendment that took place was prior to that. And the Thomas decision dealt with very specific statutes. They did not deal with the constitutional change itself. So saying you're relying upon this when we were dealing with two specific statutory nuances, it's kind of a hard sell to make. Thomas did what it did, but how does Thomas, done afterwards, change what was done in 2006? How do you do that?
thank you. That's a good question. From my perspective, the Bright-Hop factors are just like any other prudential limitation on this court's authority. The
Why is it a
justiciability factor-
limitation on the court's authority if in fact the court chooses, which it should, to follow the Constitution as in fact announced and enacted? It's not our job to make the law. The people of the state did by adopting this constitutional amendment. So when they did that, that in fact is the law. It was not invalidated unless you find something that I'm missing.
No, that's correct, Your Honor. The minimum wage amendment, as this court found in Thomas, impliedly repealed the exemptions contained in 608-250. But under Bright-Hop, this court has the authority, the prudential authority, to limit the retrospective application of its decision in Thomas.
But did it in fact, did Thomas actually do that? Or did Thomas only deal with the statutory construct of one other statute that it specifically related to?
No, Thomas did not deal with the retrospective application or the prospective application of its decision. That's why we're here on the writ. We've asked this court to limit the applicability of the Thomas decision, make it prospective from 2013 forward.
You know, counsel indicated earlier that perhaps the reliance issue isn't particularly genuine because you had an opportunity to file a deck relief action as soon as the amendment was passed. Can you address that?
Yes. The proper method to seek relief or seek clarification of the minimum wage amendment and its effect on 608-250 likely would have been, or it would have been possible to file a request for an opinion from the labor commissioner under Chapter 607 of the Nevada Revised Statutes. But in this situation, on the record before the court, seeking that opinion seems like it would have been a useless exercise because the industry already knew how the labor commissioner was enforcing the law. The labor commissioner was enforcing the law by not enforcing it. It was holding all claims by taxicab drivers under 608 for minimum wage in abeyance, pending resolution of a decision from a court of competent jurisdiction. And while I recognize that the decision in Lucas is not a decision from this court, at the same time, Nevada is a state that has historically relied heavily on the decisions from both the federal court and this court in providing practitioners and business with guidance. For example, in Herald's Club, which is a 1970 case involving the 608-160 and the application of the tip credit, Herald's Club adopted wholesale the federal court's decision in Moen, which found that individuals in the line, that defined who was in the line of service and eligible to participate in the tip pool. So although, and I'll conclude in saying this, although Lucas isn't from a decision of this court, it's persuasive and it's reasonable for practitioners and businesses in Nevada to rely on a decision from the United States District Court. That's a
So
reasonable thing
unlike
to do.
Boulder, you're saying you relied on Lucas?
Yes,
Okay, thank you.
thank you.
Well, if I may, before you sit down, so did you enter into a settlement agreement like Lucas did? Did you, that wasn't consistent with the interpretation of even Lucas?
Well, I don't believe that, and I'm not aware of it, I don't believe my client was sued or had any claims against it, which would have brought about a settlement agreement like that defined in Lucas. Lucas involved, to my recollection, both.
So the answer is you didn't change your wage practices?
No.
Okay.
We would not.
Thank you. May it please the court, this is Leon Greenberg. I am again arguing on behalf of the respondents in respect to this petition. The invitation that the court is hearing from petitioner to apply Breithaupt in this expansive fashion would really be an invitation to chaos. It would be an invitation to a repudiation of the rule of law itself. Essentially, any defendant who is found to have had some colorable defense to a new law. We're not talking about a prior judicial precedent. We're talking about a newly enacted law. In this case, it's a constitutional amendment. Any defendant who can come into a courtroom and say, well, yes, this new law was passed, and of course I'm charged as a business operator or as an individual with knowing about the laws, but I don't think this law applies to me or my industry. And rather than come to the court affirmatively and seek a declaration of my legal responsibilities, I'm just going to wait to be sued. And then when I'm sued, I'm going to come to the court and say, well, hey, it really isn't fair that I should now have to face this liability because I had a good faith belief, I had a good argument. You see, certain jurists believed my argument and adopted it. I still lost, and I was still found to be in error in my legal position. This is not consistent with our system of justice. I mean, we can go back to Justice Marshall in Marbury v. Madison, where after noting that the government of the United States is considered a government of laws and not men, went on to state that it would certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Now, the legal right at issue here was not created by this court in 2014. It was created by the Constitution, by the people of the state of Nevada. My clients are entitled to have their rights enforced. This idea that Breithaupt somehow opens the door to a special dispensation of liability in this circumstances, it just doesn't make sense. I mean, Justice Hardesty, you were discussing Breithaupt and the Chevron case, and as Breithaupt noted in a footnote, as counsel for petitioner was discussing, Justice Antonin Scalia, who recently left us in 1990 in American Trucking v. Smith, was very critical of the Chevron analysis, and he stated, quote, "Prospective decision-making is incompatible with the judicial role, which is to say what the law is, not to prescribe what it shall be." And he went on to make an observation particularly
germane to this case, which is, I quote, "The notion that our interpretation of the Constitution in a particular decision could take prospective form does not make sense." This court in 2014, as Justice Douglas was, I believe, stating, simply confirmed what the law was as the people of Nevada enacted in 2006 when they amended their Constitution. This court was overruling a particular interpretive mode, a defense to the liability that was clearly stated in that law. Now, I understand that, Justice Paraguay, you had questioned counsel for the petitioner about why they didn't seek declaratory relief. Well, they say, well, we relied on the labor commissioner. Well, the labor commissioner relies on the attorney general. I mean, he's empowered to ask the attorney general to give him a legal opinion, and he gave him his opinion. The fact that the labor commissioner, as a matter of policy, after all, the labor commissioner is a political appointee of the executive branch of our government, may have felt that he didn't want to follow that opinion. That was a policy decision that he made. He didn't have any independent legal authority to issue a different opinion. He didn't issue a different opinion. So to the extent that...
Well, if he was fairly confident in the attorney general position, don't you think he would have gone forward and acted on those claims rather than hold them in abeyance?
Well, if we examine the record, Your Honor, the declaration that petitioner was referring to from Mr. Sackelheide, who was the deputy labor commissioner, I think briefly he was the labor commissioner at one time, he was referring to the uncertainty in the law that his department viewed in the light of the Lucas decision in 2009, which, as we've already discussed, was not binding precedent in any fashion, except on the parties to that case, of course. Now, they decided not to take an enforcement position at that time. That's what the record demonstrates, because they felt it would make more sense to have the court sort out this issue as to whether Judge Jones' view of the law was in fact correct. They weren't ratifying what Judge Jones did. They never issued an opinion saying his analysis, which this court rejected in 2014, was correct. They just simply said, well, as an administrative matter, which makes a certain amount of sense, their resources are limited. If the state of the law is uncertain, they see that this issue is being litigated by private parties. The Lucas case was still ongoing. It could have gone up on appeal. Ultimately, it settled and it went to judgment in the context of Judge Jones' decision. So they simply made a policy decision there, Your Honor. It wasn't a legal opinion. It wasn't something that the industry could rely upon. Essentially, what the industry decided to do here is they said, well, we like this position. We like this view of Lucas. We like adopting this view that we will raise as our defense in any subsequent litigation that comes along. So we will simply rely on that. They made a conscious decision to rely on that. This is not a situation where they had no foreshadowing. I mean, there was an inquiry previously about the equities involved here. Well, the maxim is, he who seeks equity must do equity. Equity doesn't give relief to those with unclean hands. The industry here had their opportunity to seek a fair and appropriate judicial guidance as to their legal responsibilities. They declined to do so. They're not coming before this court with clean hands, much the contrary. Now, Justice Gibbons, you had asked counsel in the prior argument about the Sandpoint decision and some of the other decisions of this court that have examined this issue of prospective application. I have read the Sandpoint decision, and to my recollection, that and the other decisions that Your Honor was referring to deal with situations where we have statutory changes, we have newly enacted laws, and the question is, are those laws going to apply to proceedings or to actions taking place prior to their enactment? This is not the issue in this case. It is undisputed that the constitutional amendment came into effect in November of 2006. So there are no claims made in this case saying that the constitutional amendment should apply to activities taking place prior to November of 2006. And there's a whole body of law dealing with whether statutory enactment should be applied to actions taking place prior to their enactment. But that is not the situation
Mr. Greenberg, I appreciate that, and I thank you for answering that question, because it did kind of vex me in trying to analyze all these issues raised here. I have another kind of administrative type issue. It's not part of this case, but is intricately woven. We have other cases in the pipeline on the statute of limitations, whether it's 4 years, 2 years, or whatever, like that, which I think are coming to us. Should we, and then if we entertain this written and announce a decision, should we cluster it with that statute of limitations issue, so we don't kind of unleash maybe chaos on this industry here, and maybe answer as much of these legal questions as we can? Do you have any thoughts on that?
I'm aware of those pending matters before the court. I certainly would welcome decisions on that. I urge the court to do its business in the most effective, efficient, and speedy fashion it can. So I don't mean to dodge your question, Your Honor, but I can't really give a good opinion as the most appropriate way to address that issue.
Those cases are slouching towards Carson City, though.
Yes, I do understand, and this court has a lot of work to do, and I appreciate you taking the time to consider this today.
But he raises an interesting point, which is, should the statute of limitations be the answer here, rather than getting into this Bright House application? I mean, if you waited too long and the statute's 2 years or 4 years, however it comes out, your claims only go back that far. And is that not the legislative judgment on how far back a person can bring a claim? I mean, to me, I think they are interrelated.
Well, as a pragmatic matter, it is certainly going to place a limit on
the inequity,
on the scope of these claims, on the perceived inequity that the industry is claiming here. And again, in respect to this claim of inequity, we have Yellow Checker Star, the respondent in this particular case, going to its union, not being able to secure the waiver that it wished, and then coming to this court and saying, well, give us what we couldn't get at the bargaining table. Essentially, that's what they're asking for now. And that certainly isn't equitable. It's not equitable to the drivers. But as a pragmatic matter, yes, the statute of limitations issue will put a limit on the scope of any liability that will flow from these claims. I know there was discussion, I believe really actually from counsel for Boulder, about the inequity that will be visited upon them or their industry if there are other damages that are awarded to plaintiffs in these cases, such as punitive damages and so forth, something beyond what are really relatively modest measures of damages in the form of minimum wages. That is a different issue that is not presented before this court. If this court wishes to reach that issue, it certainly could. But again, that presents
but those issues are in those cases, correct?
Well,
so, I mean, does that argue against writ relief?
What I'm trying to explain is that part of what petitioner's argument is here today is that inequity will be faced by them on this liability because of their exposure to these additional damages, punitive damages, and so forth. Now, the analysis on that, I'm just pointing out, is different than the analysis in terms of giving the relief that is requested by the petitioners explicitly under the Constitution. Unfortunately, this court is charged with a difficult task in dealing with this constitutional amendment because although it has some very clear and express wording, it also doesn't address directly certain other issues, such as we've been discussing, the statute of limitations that's applicable. It grants a right to all forms of relief that are available in the courts of the state of Nevada, but it doesn't specifically use the term punitive damages. So
you'd have a Hansen versus Harris kind of argument. I know you don't want to concede that point, but there are other protections in the law, is your point.
Yes, I mean, this court has dealt with these issues under a separate analytic standard and has handled them appropriately. So it's not this sort of sky is falling type of situation that I think the petitioners have presented to this court in respect to their claim of inequity here, which again is not actually substantiated by anything. We have no idea what the receipts of these businesses have been since 2006. If they had Arguably, they could have gone and restructured their operations, limited their operations so that they didn't have cab drivers engaged in servicing taxi cabs during periods of time when the business simply wasn't there. Those were economic decisions that theoretically they could have made, but we don't even know if they would have made them. And quite honestly, that's not even the issue before this court. This court is not here to gauge the wisdom of the policy behind the constitutional amendment or how the taxi cab business should be operated in the state of Nevada. It is a highly regulated business. They have recourse to the Taxi Commission for relief.
See, that's their argument and why we should apply Brighthouse, as I understood their argument. They're saying it isn't that every time you interpret a statute, you're going to create new claims, but here we have a heavily regulated by the executive branch industry that was taking a position as to the proper interpretation of that law. I mean, that's their argument, isn't it?
Well, the Taxi Commission never took an
Okay.
issue with the payment of minimum wage. That's outside of their jurisdiction. The Labor Commissioner never supported the Lucas decision. They simply elected to take no action in light of the decision. To the extent that they sought a legal opinion, they went to the highest law enforcement officer of the state of Nevada, who's charged with a duty independently as the Attorney General to give an opinion on the
Why do you
legal-
suppose
on the
they
laws.
didn't take action then?
Well, quite honestly, Your Honor, they have a lot of responsibilities. And the Labor Commissioner, to my experience, only acts on complaints that come to them rather than proactively get involved in enforcement actions, which is different, for example.
But
Yes.
they held those claims in abeyance. You're telling me, or you're trying to tell me that they couldn't have acted on those claims?
They could have acted, and there is in the record a history of claimants coming forward after the Lucas decision or around the same time of the Lucas decision and individually filing claims and asking for action on what they perceived were minimum wages they were owed. And the Labor Commissioner said, we are putting this on hold pending a resolution in the judicial forum as to the scope of the law. What I would also point out is simply that their position in not taking affirmative action to enforce the law in this area is just as a policy matter different than the federal government, which has taken very aggressive enforcement actions against this industry to enforce the federal minimum wage law. And it is in the record that there have been a number of actions by the federal government invoking federal minimum wage standards and violations against Yellow Checker Star and other companies. So it's not as if the industry was completely unaware from its own experience that there were minimum wage issues affecting its industry. But my time, I believe, is up unless the court wishes.
Very quick question. Looking at Chevron, Brythop, and Harper, what is your feeling about controlling or non-controlling of the three cases?
Well, my view is that Justice Scalia really is correct and consistent with his statement in American Trucking, which is that prospective decision-making doesn't make sense. It is not our tradition because it deprives litigants of the vindication of their legal rights. I mean, this is why it was unknown at the common law. The Magna Carta itself, one of the rights it enumerated, which was at Article 52, was to create a process for giving restitution to those who had been unlawfully dispossessed of their property or rights. So this concept that someone whose rights are violated is entitled to restitution, is entitled to a material relief, is at the very heart of our system of justice. So I don't see how prospective application can be applied. I mean, we had a discussion earlier here. There was an invocation of Miranda, where there's Mapp versus Ohio, for example. But in those situations, we were dealing with declarations of expansive constitutional interpretations on the order of, for example, Brown versus Board of Education overruling Plessy v. Ferguson about the development of our legal doctrines based upon these broad concepts of equal protection and due process. We're not talking about the application of a very specific newly enacted legal right which came into being in 2006. So the practical considerations that controlled the prospective application, those sort of decisions just don't enter into the picture here. But even if we were to open the door to them and say, well, possibly we could consider them and not violate the fundamental rule of law, how can we in this case when there was a wealth of warning to the industry that they had a problem here? The industry knew they potentially had a problem. I mean, Yellow Checker Star itself knew because they went to their union and tried to deal with this issue with the union. So there is, even if Breithaupt was to be invoked here, there is no basis to apply its sort of exit from the rule of retrospective application. It just doesn't fit. But I've taken up quite a lot of your time, unless there is something more.
Colleagues, any other questions? All right, thank you.
Thank you.
I neglected to formally reserve some time, but I had 2 minutes.
Yeah, I think you do have about 2 minutes, minute 54, so we'll give you 2.
I just want to address a few things. First, one of the fundamental principles of law is that individuals and businesses are entitled to know what their obligations are under the law in order to comply with them. The minimum wage amendment was enacted through direct democracy. It's not a model of clarity. There are at least 4 writ petitions on fundamental issues that go to the core of the minimum wage amendment and how it should be applied before this court. The statute of limitations, the meaning of health care, the distinction between whether health care insurance has been offered or provided, and tip inclusion, whether it's appropriate to consider tips when you're considering whether the minimum wage amendment has been satisfied. So from our perspective, this is exactly the kind of case where application of the Breithaupt factors makes sense, particularly since the exemptions on which this industry relied had been in place since 1965. The second thing I wanted to address is the CBA waiver issue.
Counsel, that seems like a slippery slope. Lots of these initiative petitions contain some weaknesses in the drafting. Eminent domain, medical marijuana, the list goes on. And I think anybody who reads many of those petitions would conclude that they contain quite a few ambiguities or uncertainties. So what you're suggesting here is that as we look at each of these in future cases, we're going to be constructing how the citizens chose to amend the Constitution on prospective go-forward basis. Is that going to be the rule here?
Unfortunately, that's possible, given the nature of direct democracy and the way that Nevada's legislature and citizens have chosen to enact amendments to the Constitution.
California doesn't do that. California's interpretations are retrospective, even on initiatives.
If I could add one last thing that I'm not aware of what California does with respect to retrospective applications of direct initiative decisions. From my perspective, Breithaupt controls this case. I do want to add one last thing, if you would indulge me. The collective bargaining exemption waiver that counsel referred to several times during his oral argument, the declaration on which that argument relies is hearsay. It wasn't raised below. And from our perspective, it goes to the merits of this issue because the minimum wage amendment contains a collective bargaining exemption. If this court is inclined to rely on that or believes that its decision today hinges upon whether that request occurred, the matter should be remanded to the trial court for an evidentiary hearing on whether, in fact, an exemption was requested. The last thing I wanted to add, and I appreciate the indulgence, is that there is a tremendous inequity that could result from a retrospective application of this case, and it ties directly to the statute of limitations issue. Because the statutory scheme only requires an employer to maintain records for 2 years under 608.115, retrospective application of this case will create an avalanche of the cases that employers cannot possibly defend. And it's not just taxicab companies. It's casual people who hire babysitters. It's people who've hired individuals who have handicaps and mental issues. There's a whole host of exemptions that were contained in 608.250 that the Labor Commissioner made an intentional decision to retain and continue to apply after the amendment was enacted. And retrospective application of the Thomas decision will expose all of those employers to a glut of litigation that they can't defend. It's a strict liability case.
So how far back, you mentioned statute of limitations and the fact that the cab companies aren't required to keep records beyond 2 years. What I asked earlier in the other case, what practical impact does that have?
The practical impact is that this case and other cases like it will be indefensible. Under 608.115, employers are only required to maintain wage and hour records for 2 years. Applying Thomas retrospectively when the minimum wage exemption, according to the Labor Commissioner, applied, or applying Thomas to a period of time when those records weren't necessarily maintained or weren't required to be maintained, applying Thomas to other employers would prevent my client and other cabs from defending their cases, especially
When
if
was
this
the complaint in this case filed?
2012, I believe. And if this court were also inclined, or if the trial courts were inclined to apply the Anderson versus Mount St. Clemens doctrine under the FLSA, where employers are held strictly liable if they don't have records, this decision isn't just a decision about retrospective application of Thomas. This is a decision about liability going back to, depending on the outcome of the statute of limitations writ application.
Counsel, those are issues that probably are left for other cases that are coming in front of us, and I appreciate your argument. But it's not the end-all, be-all of why we should or shouldn't rule persistent with our Constitution. You've indicated your reliance on Brethart. Again, why shouldn't we look at the other cases that the court has talked about that go the opposite way from the case you wish to rely upon? Why not Harper? Why not the other cases that have come down from our Supreme Court, U.S. Supreme Court?
Thank you. Harper and Jim Beam, which are the two Supreme Court decisions that were issued shortly before this case, or before this court issued Breithaupt. Those are the two, American Trucking, those are the cases in which the U.S. Supreme Court reconsidered the decision, the standard in Chevron Oil versus Huson. Those decisions were issued prior to this court's adoption of Breithaupt. This court, since Breithaupt, has applied the Breithaupt factors without comment in 2013 and 2014. It would be my position that under stare decisis, Breithaupt remains controlling. And if the court was inclined to reconsider that, perhaps further briefing would be necessary. But given the state of the law, the court should apply the Breithaupt factors in this case.
Okay, colleagues, anything? All right, thank you much for the arguments. Again, the briefing was outstanding, and we appreciate you being here. This court will stand in recess. This case will stand submitted, and we'll be back at 11:30.